case number 114463 in the matter of Scott Michael Minter.
May it please the court, the Office of the Disciplinary Administrator appears by Kim Knoll, Deputy Disciplinary Administrator. I am not reserving rebuttal time. As this court is aware, Mr. Minter stipulated to convictions and that he violated the Kansas Rule of Professional Conduct 8.4b. The hearing panel found as aggravating factors that there was a pattern of misconduct and that he engaged in multiple offenses. In mitigation, they found that he had no prior discipline, he was not motivated by dishonesty, he was addicted and chemically dependent, he cooperated in the process, he was remorseful, he's a young lawyer, he was only admitted in 2011, he had a good character and reputation in his community, and he did serve 10 months in prison, which were other sanctions. I believe that we are required to point this court to the ABA standards that are applicable, and as I argued at the panel, that is standard 5.11a, and that provides that disbarment is generally appropriate when a lawyer engages in the sale, distribution, or importation of a controlled substance. And as this court is aware, his underlying conviction was for distribution and sale of marijuana. The annotations cite to a couple of cases. And I believe our office's position is that we have to set the baseline for what the discipline would be, and that is why the recommendation remains disbarment. I believe it is appropriate for the hearing panel and for this body to take the mitigation and apply it to that baseline and determine where the punishment should actually end. And that's what the hearing panel did, and they came down with a recommendation of indefinite. I would point out there's 2 Kansas cases that deal with lawyers that were convicted of possession with intent to distribute. The first one is the Diggs case, which is at 256 Kansas 193. And the second one is the Robertson case, which is at 256 Can 505. And I believe the first one, Diggs, was... it was a controlled substance, and the second one was cocaine, which at the hearing panel there was some discussion about the schedule. Unfortunately, marijuana is on the schedule as well as cocaine or methamphetamine, and it's our position that the type of drug does not necessarily make a distinction. It's the act of the sale that is the problem.
What were the dispositions for Diggs and Robertson?
They were both disbarred. And Robertson, the panel actually recommended a censure. And in that case, they found that he had a good reputation. He had a significant number of clients. He cooperated. He had no prior discipline. He was actually entrapped in one of the criminal counts. And the panel found no aggravating factors, and this body determined that it was the sale that required the disbarment in applying the ABA standards. So I think that case is pretty analogous to what we have here as far as the number of mitigating factors. The only difference is marijuana versus cocaine, which it's the sale, it's not the type of controlled substance that is the problem.
Any further presentation?
No.
Any questions? Thank you, counsel.
May it please the court. At this time, before making any statement, I would like to have Mr. Minter approach the podium and present to you his statement. My request is that you uphold the panel's decision. The panel took a whole day in listening to this matter, And I believe that their order fairly and accurately states the basis of their decision. There is no question that the ABA standard that is applicable generally stands for the proposition of disbarment. I suggest to you that this is the unusual case in which the panel determined that the appropriate sanction was the indefinite suspension. And if I may, at this time, I would like to have Mr. Minter come and present to you, please.
Counsel,
Yes, sir.
before either of you sit down, could you address how we would address the Robertson case? And what would make it distinguishable, or why we would do less than disbarment?
Well, I think it's fair to say, Your Honor, that these cases should be taken on a case-by-case basis. It is not a mandatory determination from Robertson. I think that clearly the standard 5.11a, it's a general standard, not one that is mandatory on this court. And I believe it is appropriate to look at these matters on a case-by-case basis. The mitigating circumstances that the panel presented in the current case, Mr. Minter's case, I think are sufficient for this court to differentiate Mr. Minter from Robertson. First of all, while I agree that the issue is not whether it's cocaine, methamphetamine, or marijuana, it's hard to argue that marijuana in this day and age cannot be clearly differentiated. It is legal in many states. If this would have occurred in the state of Colorado, we wouldn't be here. If it occurred in a variety of other states, the likelihood of us being here would not be applicable. So I suggest to you that the general principle in 5.11a, as was applied in Robertson, should not be a mandatory determination as to what the outcome of this court's decision should be with Mr. Minter.
I wasn't clear from opposing counsel, but my understanding was that at least in one of those two cases, Diggs or Robertson, the panel had recommended less than disbarment, such
true.
as here, but this court, for whatever reason, said, no, we're going to disbar. So,
And the court certainly has the authority to exercise its judgment in determining what the appropriate sanction is. In that case, I believe the sanction recommended, and I believe it was the Robertson case, was a censure, which is not what occurred in Mr. Minter's case. The proposed sanction is an indefinite suspension. And as the panel said, Mr. Minter is a young man, 32 years of age, had a sterling reputation as a lawyer. I must tell you that my office became involved in this matter on a pro bono basis because this young lawyer was stripped of everything he had. He ended up following his voluntary stop of his practice, painting houses, just trying to make a living. He has spent 10 months in a state penitentiary. He has suffered significant consequences as a result of his clearly illegal and inappropriate behavior, the distribution of marijuana, which is a controlled substance. So I'm not suggesting to you that simply because it's marijuana that he didn't do anything wrong. Quite the contrary. But I do think it's important to place it in context with what's going on around the country. And in that regard, to perhaps look at this case differently than if the controlled substance being distributed was methamphetamine, heroin, or a class 1 serious drug offense.
The panel based its decision on disbarment versus indefinite suspension on the notion that indefinite suspension would give the respondent some hope of returning to the profession. And context matters in this regard. And, you know, it wasn't too many years ago that disbarment really was a professional death penalty sort of thing. But that's changed. I mean, we've now got a couple of cases on the books where disbarred lawyers have returned to the profession. So in some respects, in my mind, I'm thinking that really where we're at is the difference between 3 years and 5 years for when we would have the 219 hearing. The 219 hearing would be over exactly the same notions, rehabilitation and keeping up with the profession and whether we want Mr. Mentor back in here. So given that, I mean, why does 3 years versus 5 years before you can file for a 219 matter? Since really disbarment, at least in my mind, is not a forever stricture on returning to the profession.
I understand what you're saying, Justice Biles, but those additional 2 years would have a significant impact on Mr. Mentor's ability to make a living. Clearly, there's no guarantee that in 3 years, if he is indefinitely suspended, this court is going to find if the appropriate request was made to the court for reinstatement, that he should be readmitted. But I would suggest to you that whether it's before this court or the Supreme Court of another state, another jurisdiction, there is a psychological difference between how we look at someone who has been indefinitely suspended versus disbarment. Disbarment is, without a doubt, the harshest form of punishment that this court can impose on a practitioner. And while it is true that there has been a change in how we deal with an individual who's been disbarred, historically, as you have stated, that was the kiss of death, as it were, and now those views are perhaps changing. It's still a significant difference between one and the other, and that bit of light at the end of the tunnel would mean a lot to this to this young man, and based upon the mitigating circumstances that the panel ascertained to be true and accurate in this case, I respectfully request that the lesser sanction be imposed as opposed to the harsher.
Do we have any more questions of counsel before we hear from his client?
Thank you very
Very well,
much.
thank you.
Mr. Mentor.
I'd first like to begin by offering my sincerest apologies to this court, every member of this court, every member of the legal community, as well as to Ms. Knoll, disciplinary office. It was certainly never my intention to bring any harm to the legal profession as a whole, and I absolutely have, and I'm very sorry for having done that. I'm also very honored to be afforded the opportunity to have due process in this matter. It's not at all lost on me. I wrote, a 5 or so page speech. It basically focused on the mitigating circumstances, because I believe that the only issue before this court is what the appropriate sanction is, considering all the mitigating and aggravating circumstances in this case. I've clearly engaged in criminal conduct that adversely reflects on my fitness and character to be a lawyer, and stipulated to the violations of the Kansas rules of professional conduct. This court is fully aware of what's on the record and what the panel, hearing panel is recommended. Before I use the rest of my time, what I've prepared, Justice Biles, I'd like to respond to your question as well. And the answer to your question, sir, is I can do a lot more good for Kansas and for my clients if I'm given a second opportunity. I filed Chapter 7 and 13 bankruptcies, and I was constantly faced and met with people and helped people who were at the very bottom in society. And they came to me looking for help, and I was able to use the education that I've worked my entire life to get in order to help those people. And right now I'm literally frying French fries and painting houses and standing on a ladder to make ends meet. And I can do a lot more good for society if I'm given an opportunity to get back out there. And I know what the case precedent is. And I fully respect any decision that this court makes. But what I'm asking today is I'm asking that this court take a step in a new direction and to allow people who do everything right and to make a complete change in their lives to have at least a small light at the end of the tunnel. This has been the most humbling and humiliating experience of my life. And I can genuinely tell you that if I would have been able to foresee what 5 seconds of this feels like, I never would have engaged in any of this conduct to begin with. So I really, I regret not having that foresight. And, my conduct didn't happen overnight. I was a marijuana user for my entire adult life, and it was one baby step after the next, after the next, after the next. And finally one day you step back and you look at it, and it's become something that you never really anticipated. But it's not definitive of who I am as a person. I'm a much better person than that, and I have much more potential and capabilities to do a lot of good things in our society. And what I'm asking you today is to please give me a second chance and a second opportunity so that I can help people and use my education that I've worked very hard to get.
Let me ask a re-entry kind of question, and I don't care which one of you answer this, or both of you. We're really talking about 2 years. It was January of 2014 when the charges were filed, and we're December now, so just make it 2. In the course of the 2-year period, what's been the road to recovery that we can look to have some notion? I mean, again, in my mind, we're talking about whether re-entry occurs in 3 years or 5 years, but the practical thing is filing a 219 will take you a year anyway, so we're talking about 4 years versus 6 years. But in the 2-year period since the criminal charges were filed, what has been the road to recovery?
Well, I've been in conduct, or I got in contact immediately with the Kansas Lawyers Assistance Program. I've attended numerous NA meetings, AA meetings. I had an attorney monitor that I was checking in with for a while. I voluntarily went to a recovery program that I did for 12 weeks with a licensed addiction counselor here in Topeka. His name's Wally Meckler. I met with him once a week voluntarily and went through a recovery program. I can honestly say that, having used marijuana every day of my life, the last day that I used was March 25th of 2013. And I haven't looked back since, and haven't wanted to look back since. So, I've done everything that was recommended to me. I've done everything that I can think of voluntarily to stay away from that sort of activity, and to try and show this court that I've been walking the correct path back to recovery. I've had a sustained period of recovery. It's been almost 2.5 years, and I want that whole part of my life to be behind me for good. Do you have anything to add?
Have you made any effort to try to work in the legal profession, like as a paralegal?
I have, Your Honor. I've sent out so many resumes and so many applications, and haven't even so much as received an email. Not even an interview. This case is going to be taught in professional responsibility classes. My name is going to be easily searched on Google. There's an enormous stigma that goes along with having been convicted of a crime. And I can tell you right now that, my former boss, Mr. Gary Hink, who testified at the hearing panel, he would hire me again right away. He would hire me again today if this court would allow it, because he knew how hard I worked, and he knows me personally. And the way I even got that job was by diving in a sink or swim situation. I would sit outside the courtroom on docket day at the federal court with a notepad full of questions, asking every bankruptcy attorney in town how things worked. And I never even sent out a resume to get my former job, because the moment that position was available, I had already put in FaceTime, and people in town were emailing Gary Hink about, hey, have you heard of this Scott Minter guy? He's really out there trying to learn this stuff. And, that's how I got that job to begin with. So, I've been out there trying to find positions for legal assistants and paralegals, and it's just, how do I? Nobody wants a disciplined attorney working as a legal assistant, unless they know specifically who you are and what you're capable of. And then you're not going to have any. It's a business decision that's made to not be associated with anybody that has that stigma attached to them, which is completely understandable. So it's difficult to find any sort of work right now that is even related to my education. And believe me, I have tried.
Any more questions? Do you have any further presentation from either counsel? If you wanted to continue with your statement, we could allow a few more minutes.
I thank you for the extra time. I think that there was one mitigating circumstance that was not mentioned by opposing counsel, and that was remorse. There has really not been one waking moment in my life since March of 2013 that I wish I could turn the clock back and make a different decision. I've not only hurt myself, but my entire family has been devastated. The legal community as a whole. I can only at this point offer my sincerest apologies for my misconduct. And I commit to never again jeopardizing my freedom, my livelihood, and most importantly, my close personal relationships. It's really difficult to summarize who I am as a person and why you should impose a lesser sanction in the 12 minute, 15 minutes that I'm given here. But I truly have done everything that I can think of to rectify the circumstances. I can only pray that this court adopts the recommendation of the hearing panel. I thank you all very much for your time, and I will respect any decision that this court makes.
Any further questions? I see none. Thank you both for your remarks.
Thank you.
Chief, may I ask Ms. Knoll a question, even though she has to?
She had, that would be fine.
Ms. Knoll, I didn't get this done while you were at the podium, but I pulled up Robertson. And and I'm looking at 256 Can, page 508. And the court cites to Diggs and notes that Diggs imposed the most severe sanction. But then the court goes on with the majority accepting censure, accepting the panel's recommendation of censure, which is not what I understood you to say before.
That is not, that isn't what I said before, and that's not what I argued, and I believe you are absolutely correct. I apologize.
That
I don't know where,
if this is Pete Robertson from Junction City, my recollection is he was practicing law as of 10 years ago. But what I could not recall whether he had been disbarred and then allowed back in, or whether he had never been disbarred.
no, a majority of this court accepts the panel's recommendation. Both myself and Mr. Gonagrai had this before the panel, and the panel had it, and I honestly don't know where the impression came from. I do sincerely apologize to the court. That's still, the ABA standard still, I believe, is where the controlling position should be.
But this does stand as an example of the court making the decision to go below that standard.
Right, and as this court is well aware, we only bring recommendations, this office, the respondent, and the hearing panel, and it is absolutely up to you, this court, to apply the appropriate standards and make the final determination.
Anything further? Thank you, counsel. We thank you all for your arguments this morning. Court will take this matter under advisement. That concludes